That's the point. There's an attempt to delay proceedings through the legal process. But that doesn't mean that when they file such applications, the court must wait for them for this application to be moved at the appellate court or at the Supreme Court.
In the face of serious accusations of deploying legal processes to delay his criminal trial, Assin North MP James Gyakye Quayson is defiant, declaring he will emerge victorious and that injustice will not be allowed to stand.
I'm very hopeful. I believe in the rule of law, and I'm very hopeful that this matter will come to a very favorable conclusion.
Plus, majority MPs accuses his minority colleague of sabotaging Parliament as the House is forced yet again to adjourn sittings prematurely due to the boycott of the NDC caucus.
I don't even believe that all of them are the courts. As we speak, some might be in their offices. This is a complete sabotage of the House. A delegation can be sent to be with their colleagues over there.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Vodafone. Our Assin North MP James Gyakye Quayson is tonight confident his criminal trial will terminate in his favor. Now, this expression of optimism comes in the wake of the Attorney General accusing him of deploying legal processes to delay the case. The AG today asked the court to proceed with the case despite the pending applications at the Court of Appeal and the Supreme Court. And of course, we'll be going to Parliament where it's taking a toll there because of the minority MP solidarity with your colleague. That's later. I want to bring in legal affairs correspondent Joseph Akable, who joins us on via Zoom right now. And Joseph, tell us about this latest court processes we are learning about filed by James Gyakye Quayson and his lawyers.
So in terms of the processes that have been filed so far, the one at the Supreme Court is asking the Supreme Court to put the trial on hold because they believe that the disclosures, i.e. the evidence that the Attorney General intends to use in the case against Gyakye Quayson, they believe they do not have the full complement of that. Then there is the Court of Appeal one that they are seeking to set aside the decision of the High Court to have his case heard on a day-to-day basis. They are equally asking the Court of Appeal to put this case on hold while it rules on that particular matter as well.
The AG is concerned about what he says is undue delay of the case.
In fact, the Attorney General made that point strongly in court, saying that he does not understand why this application has been made for the trial to be put on hold in the first place because, as it stands, various processes have been filed, but no court of competent jurisdiction has said that be put on hold. And so he believes that this is just part of a trend that is happening. Each time they make such applications to just frustrate the process and the case does not progress at all. Deputy Attorney General Alfred Chayebwa made the same point when he interacted with us after proceedings.
We came to court this morning only to be told that the accused person, through his counsel, had filed an application, one, at the Court of Appeal, seeking to stay proceedings, and then two, an application at the Supreme Court seeking to quash and prohibit the judge from hearing the matter. Now, per practice, if you file such an application, it does not automatically stay proceedings. So we made a point that notwithstanding the fact that these applications have been filed, the judge will be right in proceeding to hear the case by asking that examination be done on PW1. The judge, after listening to us, said he will be giving a ruling on that specific issue on Tuesday.
I mean, what does your office make of the fact that for almost a month now, you have virtually not been able to make any progress on this work? And the AG makes the point that it appears there is some attempts to halt the trial effectively.
That's the point. There's an attempt to delay proceedings through the legal process, which you will say, fine, it's within their right to use the legal process to fight their cause. But that doesn't mean that when they file such applications, the court must wait for them for this application to be moved at the appellate court or at the Supreme Court. So we are concerned about that. But we are ready. If I told you last week, we come to court to speak law. This morning, we have spoken law in court. Tuesday, we will know what the judge will say, whether the judge will agree with us or disagree with us.
And what does Mr. Quayson's team make of this view?
I mean, they disagree, and Mr. Chikata made that point in court that it is an issue of concern. They just have issues with the process that is being implemented, and it's not the case that they want to delay the court. Abraham Amaliba, who is Director of Legal for the opposition NDC, says the AG was wrong to have suggested that there's any attempt to delay the court process.
The application for certiorari, which is before the Supreme Court, in that application, we are seeking for some reliefs, which are that, one, because the Attorney General failed to fully make disclosures to lawyers of Gyakye Quayson, there was the need for the Supreme Court to determine that matter because the disclosures were not fully made. We don't know from our side what the Attorney General was hiding from because the rules are that you must fully disclose. But in this case, the Attorney General did some half disclosures, not full disclosure, which meant the Attorney General had something to hide. It is for this reason that lawyers for Gyakye Quayson indicated to the court that because disclosures were not fully made in accordance with Republic versus Bafo-Boni's case, there's a need to stay proceedings. And so this argument was forcefully made, and the judge adjourned to the 18th for a determination whether or not to stay proceedings or to go ahead with the hearing, the trial. The AG made a point in court that, as far as he's concerned, he thinks that these are all moves to ensure that the case does not progress at all. I mean, what does Mr. Quayson still make of that?
It is mind-boggling that the Attorney General should be speaking that way. This same Attorney General, in a different matter, ex-party Kenya Japan, indicated to the court, and that was at the Supreme Court, that because disclosures were not fully made, clearly it was wrong for the court law to proceed. And in that case, Justice Yoni Kolende actually said that the refusal of the court, that is not the work of an Attorney General.
And Blay, we've been hearing today from Mr. Quayson himself. Rarely speaks after the court ends on a daily basis, but now he's speaking and he's sounding a bit bullish about the trial.
In fact, there were a number of individuals who came to lend their support to him at the court premises. So after proceedings, he walked up to them and addressed them, and he indicated to them that he is confident that he will emerge victorious and that injustice will not be allowed to thrive.
I just want to take a moment here to thank all of you coming out of your busy schedules, devoting your time to support me. It means a lot to me, and it means a lot to the party and DC. And also to all Ghanaians. This is a fight for justice and democracy. Because today it may be happening to Quayson, another day it will be happening to someone else. And we want to stop these things in their tracks. A true democracy should have a transparent system, a fair justice trial, and no kangaroo courts. So I'm very hopeful. I believe in the rule of law, and I'm very hopeful that this matter will come to a very favorable conclusion. God bless you.
And Blay, tell me, the minority MPs were not in Parliament today. Parliament was forced to adjourn. Were they all in court solidarizing with Mr. Quayson?
No, Evans. In fact, I can say that the court does not even have the capacity to accommodate the 137 of them. In fact, those who came in, per my count, will not be up to 30. At best, maybe 25. In terms of the individuals who made it, the minority leader, Dr. Kasela Toforson, was there. The deputy minority leader, Emmanuel Amakufibua, the chief whip, Kwame Gavin Sabuja, and other members of parliament like Francis Osu, Samuel Okujeto Black, all made it, but definitely not up to the 137 members of the minority side.
Thank you very much, Joseph Akabile. I want to bring in the Director of Legal for the NDC who joins us on the telephone line right now. Thank you, sir, Ms. Amaliba, for your time here on Top Story. Is it not in the interest of Mr. Quayson that despite pursuing all these legal avenues, the trial goes on? Is he not worried about how the case is delaying, and now his colleagues have also effectively been forced to abandon Parliament to join him in court?
Indeed, it is in the interest of the accused person for his lawyers to provide the best of legal services to him. That includes, if we are dissatisfied with the ruling of the court, to appeal against such rulings. It will be wrong for lawyers to send the accused person to court and just hand him over to the prosecution to maul. And so what we are doing is not against his interest, it's rather in his interest so that he can get the best of representation.
And when it comes to the daily hearing of this case, you obviously are opposed to it. The suggestion had come today that this is part of a legal strategy to slow down the hearing of this case. You've rejected that, but lawyers know sometimes it's part of legal strategy to slow down the hearing of a case.
When you listen to the Deputy Attorney General, he said that what we're doing was within our rights. And indeed, none of the processes filed are unknown to the courts. These are processes that are known to the courts, which are available to all parties. And so there's no attempt to frustrate any hearing. But if a court says that, and the Supreme Court says that, in a trial of this nature, a criminal trial, you must fully disclose. Even the disclosure includes documents that you are not intending to use. If you are supposed to fully disclose all documents that you intend to rely on for the accused person to also prepare his case, and the Attorney General decides to, as it were, disclose and keep some to his chest, it is only in the interest of the accused person that we have the court force their prosecution to provide all those documents.
And explain to me why there appears, at least watching what unfolds in court on a daily basis, and today happened again, this feud that it appears to be brewing between the Attorney General and Gyakye Quayson, who's leading the case for James Gyakye Quayson. Today, there was another exchange of words when the Attorney General walked in. What's happening there? I mean, is this part of something else bigger than what we're watching unfold in court? The judge himself had cause to complain about this tension.
Well, sometimes tensions do rise and they go overboard. But in this case, you find the Attorney General using words that are unacceptable. In this particular case, Senior Counsel Gyakye Quayson simply drew the court's attention to the fact that, and everybody knows that when you are a lawyer, you get up, you announce your presence. And the Attorney General didn't do that. So he just told the judge that he expected the Attorney General to have announced himself. Because earlier, the Deputy Attorney General has announced himself. And so indications were that he was going to, as it were, conduct the case. Attorney General walks in after the Deputy Attorney General has announced himself and does not announce himself, and then decides to take over the conduct of the case. Then Senior Gyakye Quayson then says that, it is important to draw the court's attention that, as the practice is, lawyers are supposed to announce themselves, and in this case, the Attorney General did not do so. Then you have the Attorney General hit at Gyakye Quayson in words that I'm not supposed to repeat again. And so I think it is the conduct, the impatience on the part of the Attorney General and the intolerance on his part is what is causing some of these things.
You expect this to ease at all?
I find it's a bit difficult to answer this question because of the continuous conduct of the Attorney General. He seems to be so whipped up. The Deputy Attorney General, in my view, is reasonable. He comes across as somebody who is ready to, exchange pleasantries. The Attorney General comes in and behaves like the whole court belongs to him and throws shades and all those things. It will be difficult for me to answer this.
Abraham Aliba, thank you very much. He's the Director of Legal for the National Democratic Congress. And let's go to Parliament now, because what is happening in court is affecting what's happening in Parliament. It's been forced again to adjourn sittings without considering crucial government business. This is the third time this is happening in Parliament. The forced adjournments have been due to the minority's boycott of the House to attend court in solidarity with James Gyakye Quayson. Kweku Asante, parliamentary correspondent, joins us in the studio. The minority MPs did come to the floor. Some of them did they? And in the end, some of them, as we saw from the majority side themselves, also failed to come to the floor. In the end, this had to be adjourned.
Yes, at the time sitting started just about half an hour to midday, there were about 15 NPP MPs on the floor, while there were no NDC MPs at all because of the boycott. So the majority side proceeded. They did a number of very light business, for instance, taking the business statement for next week, and also had to do the correction of votes and proceedings. But they did not have the numbers to be able to continue to do any meaningful business, and they had to adjourn, Evans.
But I'm curious, Kweku. I mean, there are 137 plus one independent candidate who votes with or does business with the MPP side. Is it not possible for them to work, form a quorum, and do business?
Right. When you look at the majority numbers, the standing orders say that to be able to do any business, to be able to discuss any matter at all on the floor of the House, you need at least 1/3 of all MPs present. That is 92. If you look at 138 MPs, they have that. To be able to vote on anything, you need 138, at least 137.5 rounded to 138. They also have that. You recall when the minority walked out on the e-levy discussion, the majority by themselves were able to pass it. So if they have the numbers on the floor, they'll be able to do business. In fact, today, one of their colleagues, Professor Richard Nyako, who is the MP for Quadras, was against the adjournment of the House. He said that they wanted to stay and do business, but they could see that they didn't have the numbers and they had to adjourn. He's accusing the minority now of sabotaging the House, and he says that he saw some of them in their offices and he wants them to come down and do business instead of going about to court.
I vehemently, respectfully disagree with him on the adjournment of the House, because if we did that, it is going to give our friends on the other side the catalyst, the oxygen to breathe, and they will hide under that to perpetuate their own decided action that, in my respective opinion, does not inure to the benefits of their constituents. Our colleagues are supposed to be here to pursue the agenda and the interests of their constituents. Nobody bars them or prevents them from solidarizing with their colleagues. But I think that in this instance, a delegation could do. Our Speaker, I don't even believe that all of them are the courts. As we speak, some might be in their offices. This is a complete sabotage of the House. A delegation can be sent to be with their colleagues over there. They are just trying to disrupt the business of the House and of the government, and this is not acceptable. So I agree with him on the score that we can vary the order of business for the day, but we should continue to do business.
And I want to bring in now Professor Kingsley Nyako, MP for Kwadaso, whose voice you just heard there on the floor of Parliament today. Also joining us is the NDC MP for Saldai, Roxy Nelson Dafiamekpo. Thank you very much, gentlemen, for your time here on Top Story.
Thank you very much. It was my pleasure to have done it.
Yes. Professor Nyako, I want to start with you. You're on the floor complaining, accusing your colleagues on the NDC side of sabotage, but from what my correspondent tells us, there were only about 15 of you on the floor. Your numbers alone could form quorum. So where are all the 137 NPP MPs who also, in your numbers, a majority of you are also not on the floor to do business?
Yeah, okay, so Ivan, very good evening to you, my very good friend Roxanne, and your revered listeners. It is true that the majority, we didn't have enough numbers on the floor or in the House today, but the point is that if you look at our standing orders, Order 48 is clear. 48.1 talks about us having 1/3 of our numbers of the House to form a quorum. But until somebody raises an issue about quorum in Order 48.2, business continues. And the correspondent will tell you that in the House, there are instances where we are even 10 or 8 or 5, but business will still go on until somebody comes in. The matter of concern is the decision by the minority to boycott proceedings anytime Gyakye Quayson is at court. And according to them, they will be at the court to solidarize with them. My opinion is that I don't have any issue when they decide to solidarize with him, but I think that it's not all the 137 minority members who go to the court. In fact, all of them cannot be at the court because the court cannot even house them. They can send a delegation to solidarize with him if they mean well. Because, see, the first day they state the boycott, I remember the minority members had filed questions for ministers to respond to. The ministers were there, but the minority members who had filed those questions were not there. And the fact is that they are denying their members effective representation. And that is worrying. You've asked a question that whose response will inure to the benefit of your constituents, and you are not there to respond to them. Let me give you a typical example. Normally, when we go to Parliament, we correct the votes and positions. And I'm happy that Roxanne is on the line. Today, his name, his gender was changed. Instead of Mr. Roxanne Nelson Defemapo, it was Miss. And ideally, if you were there, either he will correct himself or myself or any other person would have done that for him. But because he was not there, he didn't get the opportunity to correct his gender. The point is that business must go on. We are in Parliament not by ourselves. We are there representing people who took us there.
But Prof, you said business must go on. Why is business not going on? Because even if you're using the quorum number, the majority side alone, you have enough men to form quorum and proceed with the business of the House. So you must take a chunk of this as well.
You didn't hear me right. I said that quorum is spelled out in Order 48.1, 1/3. But Order 48.2 talks about the fact that somebody at the time of commencement of proceedings in the House should raise an issue of quorum.
If the person does not raise it, it goes on.
If nobody raises an issue or a matter of quorum, proceedings continue. There have been instances where we have 5 or 10, but proceedings continue.
Yes.
Okay, so if nobody raises it, business continues.
Yes.
You see, the minority represents a section of our population.
Yeah, but that shouldn't be your concern. You should just be in the House and do business. Let them suffer the consequence. Let them suffer the consequence of their inability not to represent their constituents.
No, I agree with you, but I'm saying that we need their side for us to collaborate and arrive at consensus. I'm not denying the fact that we didn't have our numbers, but I'm saying that regardless, business could still continue. Probably, because of the boycott that they had announced earlier on, might be a reason why some of our colleagues didn't show up.
Okay.
But I don't support that. But I'm saying that our colleagues should do their constituents and the nation a very good service.
Okay. Stay with me. Let me bring in Roxanne Nelson, the family. But Roxanne, you accept that what you're doing is sabotaging Parliament. This is a deliberate plot to sabotage the work of Parliament.
Now, Dr. Nyakun and I relate very well as people who are very, very particular about parliamentary procedure and processes. So I don't want to be hard on him, but Dr. Nyakun, please cut the hypocrisy. You have over 2/3 of your members following the vice president touring the Ashanti region. That is why they are not in the chamber. You are rather concerned about minority members who are solidarizing with our colleagues, Honorable Quayson in court, the Honorable Minority Leader in court, the Honorable Collins Dawda in court. That is all bothers you. But there are people following the vice president around campaigning, doesn't bother you. Who do not come to Parliament to work, that does not bother you. Let us be principled in this matter. Article 97(1) It's very clear as to the grounds upon which a member can leave parliament. Go and check one of the grounds. When you cross carpet, when you leave your caucus and join another caucus, that is one of the grounds upon which you can be removed from parliament. So by necessary application, it is our duty to protect the interests of the caucus, the NDC caucus in parliament. So what we are doing, we have a basis in law and the constitution to make those political demands. You are worried that we are sabotaging government. Isn't government sabotaging the rights of our member in court? Is it not the government that is persecuting our member in court?
No, but I'm surprised you say that. He's before a court of competence jurisdiction. This is rule of law. How is that sabotage?
How is that not a sabotage? Where the facts of the case are such that prosecution will fail, how is that not a sabotage?
But let the court decide that.
Exactly. So let us also assert our rights under law. So don't let anybody in government cry baby. Don't let anybody in government be crying for us withdrawing consensus in parliament. We will not do that. We will not do that. And let notice be served. The matter has been adjourned to next Tuesday. Again, we will not be in the house. So we will not back down today, we will not back down tomorrow. The government can find time and prosecute us in court. We will also find time and support our member in court. In any case, we've been asking the Attorney General to come to Parliament to prosecute bills that is brought to Parliament to be passed into law. He won't come. Today he was in court arguing, but he won't come to Parliament to lead the bills that he has brought to be passed into law. So he can find time to do persecution, but he won't find time to do parliamentary business. And you think that I should support him on the floor?
Roxing Nelson Defemekpo, thank you very much. He's a member of Parliament for South Dai. Earlier, you had Professor Kingsley Nyako, who is an MP for Kwanda. So he served notice already. He's been adjourned next week, Tuesday. Parliament will not be working on Monday, but Tuesday they are expected back in the House, and they served notice tonight that they will not be there because they will be in court, solidarizing with their members. And what do you make of this? Let's continue the debate on many social media platforms. Ghana Connect begins in a minute.